Thank you, Madam Chair. Mr. Delrahim, I'd like to start with you, if possible. Back in 2020, you were the head of the Antitrust Division at the Department of Justice. And in 2020, you issued, along with the FTC, of course, the 2020 vertical merger guidelines while you were there. Tell me why you thought that was important.
Thank you, Senator. So as we litigated the AT&T transaction, we saw that the courts were generally not comfortable. It was, as mentioned, it was the first case, not the first enforcement case. Professor Salop has got a great paper of the number of enforcement matters that have either ended in a consent decree or abandonment, but it was the first one litigated because we couldn't get to a resolution. Then there were several other transactions that we were involved with. And when we looked at the guidelines, one of the benefits of the guidelines when you have them, and I think they've generally served in a bipartisan way well, both agencies, and they have been updated periodically with the benefit of the expertise of experts like Professor Rose, Professor Shapiro, Carlton, and others who have come to the division, is that it provides transparency to the public, to the enforcers about how the law is, and that's really important, and to the judges. When there is support, both in the law and the accepted economic thinking, those guidelines have value. If they do not have any value because the courts will say, this is aspirational. You want to change the law, go to Congress. This is the right place to do it. If there isn't support for them, what I fear is the courts will begin dismissing them and they really don't have any value. What we wanted to do was provide a guideline, a transparency document at the Justice Department and the FTC. Fortunately, we were able to do that. And synthesize the body of the law and economic thinking on vertical mergers to serve as a recipe book for both business community, enforcers, practitioners, and most importantly, judges, so they can rely on that. I thought, it was unfortunate when the Federal Trade Commission unilaterally withdrew those without replacing one, and then they brought several cases. Frankly, I think, had they had a guideline that they could have pointed to, that might have helped them in some of the litigations which they lost and have created, law on the other side of what their enforcement objectives were.
I assume you were a little surprised when they did that, when they walked away from those, when they withdrew them.
To be honest with you, I was less surprised, but saddened. I was very glad that the Justice Department did not do that. Yeah. And Assistant Attorney General Cantor kept them in place until there's a replacement, because frankly, it was one that's widely recognized, and they're acceptable. And those guidelines are the 2020 guidelines. So it was unfortunate, but such is life.
Now, as of this morning, we've got a new set of guidelines in place. I assume you've had at least a little bit of chance to take a look at them. To the extent that you have, are the new guidelines, in your view, sufficiently robust to cover the nuances presented by vertical mergers and the lessons learned from recent losses in enforcement actions in that area?
I really don't know. I haven't had the time to digest those guidelines. The one thing I do hope is that, as we look and unpack those guidelines, look at them, is that they are supported by current economic thinking, most importantly, recent cases, because without that, it is less useful. The one thing I can say about them is that I think they recognize the efficiencies of merging two guidelines into one, and that's a good thing for the government.
Historically, it's not been done that way, right?
Right. We've had the horizontal merger guidelines, and then from 1984 until 2020, we had the non-horizontal merger guidelines. That was the DOJ. So we now have one comprehensive guideline, which, as an administrative matter, is good.
Oh, okay. So
But substantively, I really have no comment. It took, the two agencies 2 years of a lot of work with dedicated folks. I don't think I would do them any service making any comments about them in the last few hours, what I've had the chance to look at them.
One thing I've noticed is that, generally speaking, these guidelines tend to cite older cases. mostly pre-1977 cases generally. But that's especially true, glaringly so, with respect to the parts dealing with vertical mergers specifically. And so as a result of that, the new guidelines don't cite, much less aggressively address, cases in which the U.S. government lost. Cases involving AT&T Time Warner, United Healthcare, Change, and Microsoft Activision. Can enforcers, first of all, what do you make of that? And I assume this is not something that should be taken as an indication that enforcers can just ignore these cases that are binding precedent, including precedent from the D.C. Circuit.
My understanding is these guidelines are up for comment, so I'm hoping that they will be updated with newer case law. Just, not citing them do not go away in future litigation. Litigants will cite them, their precedent. And I think the courts, you've had courts that have ruled against the division and the Federal Trade Commission. By the way, these are not, Judge Bork courts. These are appointed by Presidents Obama, Presidents Clinton, Presidents Biden, very recently. And I'll add one more case to the list that you mentioned, another vertical one, which was the Meta within litigation. That's another one that the agency's lost and has vertical components.
Right. It seems pretty significant to cite those recent cases, especially recent cases in which the government lost. I'm not quite sure what to make of that. Now, you mentioned Judge Bork a minute ago. Am I supposed to read anything into that, the fact that they didn't cite any pre-1977 cases? Well, very few generally, but definitely none in the part of the guidelines that deals with vertical mergers in particular. Is that a Bork thing?
I don't have any insight into that. I doubt it. I think there's also just less. One of the reasons Congress wrote the Hart-Scott-Rodino Act was before that you had parties merge, then the government came and enforced and had to unscramble the egg. It was not a clean process. And because of that, you had a lot of cases published. People think that you don't have a lot of published opinions because the government has not been enforcing the law. That's not the case. It's because Congress put in this Hart-Scott-Rodino regime where before you merged, you had this period of time, not to get approval, but at least give the agencies a chance to take a look at it. And that's, I think, a large reason. Of course, we've had cases since because the parties have disagreed. But I think that's the large reason why we haven't had as many published opinions over the years as we did prior to the Hart-Scott-Rodino regime.
Right. No, I'm not someone who likes per se rules. I'm glad, for example, that Dr. Miles is no more. I agree with Judge Bork that per se rules generally are to be avoided, in part because they miss out on a number of things. Historically, merging parties in a vertical merger would point to efficiencies and pro-competitive benefits presented by the would-be vertical merger. For example, the elimination of double marginalization is known as EDM. Not the EDM that's a genre of music that's cool too, but this kind of EDM is also very important. They don't talk about this kind of EDM at raves, as far as I'm aware, but that's a different thing. Do you expect that the DOJ and the FTC are going to credit or not credit these arguments as they've previously credited them, even if we have recent case law that credits EDM?
I would assume courts will demand that. So again, I was on the losing side of the AT&T case. In that litigation, Professor Shapiro was our testifying expert. I made the decision, and I think everybody agreed, that in court we have to admit the efficiencies from the elimination of double marginalization that occurred in the AT&T case. Now, the court took that into account to try to find it. We had a case despite the efficiencies, but I thought that was the right thing to do. That's we're not just private litigants at the Justice Department. It was, I think, the honest thing to do there, and I hope that the future guidelines reflect the efficiencies that have been well accepted amongst economists as well as in courts.
Thank you. Senator Bluen.